Hello, my name is Hanna Carey. I am a senior at the University of Mary Washington, and I will graduate in May 2021 with a degree in political science and a minor in business French. I'm here today to discuss my research and analysis throughout the course of the past semester for my capstone project, which was part of being involved in the UMW Honors Program. I would like to start by providing some background on the subject matter of my project and how I landed on this particular topic for my research. My research is centered on the Catechism and Constitution, and I looked at the role of faith in recusal on the Supreme Court. So I chose to study the impacts of Catholicism on Supreme Court justices for a couple of reasons. So throughout my childhood, part of my identity was being a member of the Roman Catholic Church. I remember going to church every Sunday. I remember observing holy days of obligation and giving up chocolate most Lents. And I remember packing a set of church clothes whenever we went on vacation that involved a weekend. I enjoyed my faith a lot when I was younger, and then as I got older, I had a harder time reconciling some of the differences in ideologies presented even by different members of my own church, different leaders of my own church. I've ended up taking some steps away personally from the church in the last few years, but I've remained very interested in politics and religion as a political science student. I've taken an interest in public policy, political theory, religious political theory, and the way religion affects our political landscape today. Now, we live in a country lauded for its separation of church and state, but we still see a lot of Catholic and Christian elected and appointed officials, and they each have varying ideas on the role that their faith should play in the decisions they make. And this is especially important in the Supreme Court because those decisions are highly visible and highly important for the rest of the country. This project began as an exploration into just Catholic justices on the Supreme Court and capital punishment specifically, but it has evolved into a look into various interpretations of religion on other capital issues and talked about the different reasons that justices have been recused or have chosen to be recused from cases in higher and more mid profile cases. Today, I will walk through the varying ideas of Catholic doctrine on the death penalty, the different ways to interpret scripture on these issues, the prominence of Catholicism in the Supreme Court, the framework in which these religious justices may be able to recuse themselves or not, depending on the lines between their religion and their position, and I'll talk about various reasons for recusal and adaptation in the Supreme Court. The Catholic Church itself is host to a variety of ideas and different interpretations, and the differences with these different ideologies can create a lot of conflict. The consistent argument that we see in this Catholic Church is similar to the argument over the US Constitution. It's just about religious scripture and the Bible and the Old and New Testaments. So a hardline traditionalist, a hardline conservative will use Old Testament text and they will back up their statements by saying this is what was written. We need to interpret it exactly as the text says, and there can be no modernization or adaptation. Whereas modernists will say that it's important to develop ideas with changing society and changing ideals. One of these modernists is actually the current Pope Francis, and he's actually received quite a bit of blowback for some of these more developed ideas. This includes instances like the death penalty, but also some other hot button issues that we see. And a lot of modern Catholic doctrine will just include capital punishment in the issues that involve the right to life. This is the same thing with euthanasia and abortion, where carrying out capital punishment in the eyes of the Catholic Church involves making the executive decision to end the life of another person, which inherently removes their own autonomy and it takes away their right to life. The justices on the Supreme Court have actually taken varying stances on this idea, and with some saying that it should remain constitutional, and others just say that it is the loss of the right to life. So these ideas are controversial and divisive in the Catholic Church and in other religious groups, and this bleeds into our politics today. Currently, 6 out of the 9 justices on the Supreme Court bench are practicing or at least raised Catholic. In a panel of 9 justices, having 6 of them be of the same religion is a significant ratio compared to other religions that may be seen on the bench. This unrepresentative ratio for the rest of the population has been echoed throughout the history of the court. There have been 15 different Catholic justices appointed to the Supreme Court throughout the lifespan of the United States, which places them at 13% of all appointed justices to the bench. And 79% of the total appointed justices have been some denomination of Protestant or other Christian denominations. Now, we kind of understand why. A lot of these universalizing religions like to see their members in these high profile positions where they make decisions and they can use their faith to demonstrate the changes that this has on a person's life. And Catholics in particular like to put a lot of pressure on their members to go into these high profile positions. They want its members to go out and show their faith through their actions. And the best place to do that is often in these high profile positions like law and government. What this does to Catholics on courts or in other important government positions, though, is it amplifies their decisions, and it makes them appear as a reflection of the church itself. People outside the church may believe that all members of the church act like a monolith, and even with the turmoil and conflict going on within each faith, from the outside they might all look like they believe the same thing. So even a hardline conservative traditionalist justice would be worried about making a bold move like choosing to enact the death penalty or championing its use because of the way that others in that church's membership might react to that. So even though Catholics tend to strive for these high profile positions externally, they may internally fear blowback from members of their own faith for making these bold decisions. There is a difference, though, between the Supreme Court and a regular trials judge. One of the main qualms that a religious Catholic person would have, a religious Catholic judge would have, is the moral responsibility of deciding on or imposing a capital sentence. There's plenty of discourse when it comes to the role of members in the Catholic Church in judicial proceedings, but there is a substantial difference between acting as a trial judge and acting as an appellate judge. Supreme Court is an example of an appellate court. The trial judge makes the initial decision in a case. The trial judge in a criminal court would be the one who decides whether to impose the death penalty or not. Should that judge be Catholic, and should that judge wholeheartedly subscribe to the Catholic doctrine that condemns the use of the death penalty, that would put him in a conflict between his faith and what President is asking him to do in his position. An appellate role simply follows the proceedings of a prior case and determines the legitimacy and constitutionality of the decision that has already been made. In the event that a capital case reaches an appellate court, the appellate judge is not directly placed in that responsible role. The decision has already been made. The appellate judge just needs to look at the process of the trial and ensure that it was carried out fairly, constitutionally, and within its realm of correctness. In this way, a Catholic justice who may have very strong beliefs personally about this decision can remove himself from that moral responsibility because the decision has been made and he's just looking at the process. So if the rest of the trial has been held fairly, the decision reached follows appropriate precedent, the lawfully appropriate decision was reached, that justice, that judge can allow that decision to go forward without being the one to have made that call. So this will not overturn a decision that justice may not particularly like himself, but it does give that judge room to maneuver in a capital case without absorbing that direct responsibility. So when it comes to recusal, or when it comes to a capital case that this judge might have a hard time reconciling between his religion and his position, a trials judge has a couple of different options. He could choose to enact a lifelong sentence, as sentence to life without parole, rather than the death penalty, should he so choose. A lot of the time, that is an acceptable alternative. There are some times where public opinion or the jury is making it clear that should the defendant be found guilty, they want capital punishment, and the judge doesn't want the blowback of public opinion, he can recuse himself, or he can plead for disqualification based on his conflict of interest between his religion and his position. And a trials judge can either do so right at the very beginning, right before the case even begins, and another trial judge will take his place who's more comfortable and can go through the entire trial and take care of that. And the case will be essentially heard the same way because it's still one trial judge, it's just a different one than was originally planned. They'll assign somebody else. A trials judge who is really interested in doing the case and thinks that they will have a lot of input on it, but can't be the one to make that decision at the end, they could technically recuse themselves part of the way or most of the way through the process. This does give the incoming judge a little bit of a disadvantage for not having all of the context, but it's still a possibility. The Supreme Court does not have the same luxury. It is not as simple for the Supreme Court justice to recuse himself from one of these capital cases because, as the highest court in the land, one of the most prominent features is that there are 9 justices on the panel. There are 9 justices who deliberate on these ideas. They confer together on the cases in their docket, and the loss of even one of them in a case can significantly alter the way the decision is made. There's no replacement or substitution process like there is at the trials court, and it changes fundamentally the way that case is carried out. Now, religion is not the only reason for recusal from the court, and there are plenty of other reasons that a judge needs to be or should be disqualified from listening to a case. The American Bar Association's Rule 2.1 outlines the guidelines for disqualification, which include that disqualification is required in any proceeding in which the judge's impartiality might be questioned. Now, there are substantive and quantitative situations that involve this idea, like a personal relationship between a judge and a lawyer, vested financial interest, or an involved history with a party in either side of the case. The difference between recusal on the grounds of holding stock in a company that's up for trial and the difference and being part of a religion that doesn't like the issue that has come up is that it's hard to quantify the substantive change that this could make in a justice's life. Operationally, the outcome is the same when a Supreme Court justice needs to be recused from a case. The Supreme Court bench becomes smaller and the deliberations are not the same because of it. However, as discussed earlier, subscribing to a religious group or a set of beliefs does not create a monolith. Not every Catholic believes the same things about the same issues, and some religious adherents are casual enough about their faith to more easily separate it from their work. While it is well within each justice's right to determine whether their vested interest lies more in their faith or their job as a justice, with so many interpretations of doctrine, it would be impossible to prescribe disqualification for a judge based solely on their religion. The potential for disqualification on religious grounds should stand for faiths beyond Catholicism and Christianity. I've already talked about how no one religion is a monolith, even though it appears that way to some outside lookers. The presence of Catholics and Christians on the court is unrepresentative of the rest of the United States, but we can only hope that future generations of the bench look more representative of the whole population. With this hope comes the possibility for different reactions to the same reasons for recusal. To those not involved in a religion, the religion can look monolithic, and you can it's easy to stereotype someone who follows a religion based on the experiences that someone might have had before. Now, America tends to let slide the actions of Christians and Catholics in the court and in the government because that's what we're used to seeing. Would the same be true of a justice of a different religion that we're not as used to seeing? We can't tell. We don't know. We haven't seen that yet. So according to the no religious test clause, it would be unconstitutional to disqualify any judge based on their religion alone. But without seeing more diverse religions on the court, it would be impossible to see how that would play out in public opinion. But in the meantime, letting a Catholic justice recuse themselves from several cases because of their religion would probably not fly with a different religion, and maybe it's important to look into that moving forward. At the end of the day, regardless of their personal thoughts and beliefs, the justices of the Supreme Court of the United States represent the highest court in the land. They're held to a standard of measured, level deliberation, and their decisions on cases are the end-all be-all. Because of this, while their religion may shape their personal feelings, their personal beliefs, their personal decisions, their job is to interpret the Constitution and apply it to their cases in an appellate role. Regardless of their faith, the justices need to understand the weight of this role. Their appointments last a lifetime. The decisions they reach not only impact the parties involved in the cases, but they shape the precedent of the rest of the country. With a docket of only a few cases per year, it's beyond important that these justices are involved in as many of the cases brought to the court as possible. This will create a more balanced panel of justices to deliberate on each case and makes use of the skills of each of the justices on the panel. The faith of the justices themselves is not as important as how they choose to use it. But it is unfair to allow for personal interpretation of one's religion to impede their ability of a federally appointed official to carry out the role they signed up for. Catholic doctrine demonstrates that every issue has multiple possible interpretations, most of which are constantly under review and can change with any growing nation. Using religion as a pre-existing condition to be disqualified from a nationally significant case contradicts the purpose of the position of a Supreme Court justice. There is no direct responsibility in the appellate role, and personal interpretations based on personal views should not be able to impact the life of another person. And it is unfair to allow a subjective, abstract ideal to impact the ability of a Supreme Court justice to seek justice on a case they are asked to hear. I thank you all for listening today, and I am thrilled to have gotten the opportunity to discuss my research from this past semester. So thank you for listening.